that we need to take up before we bring jurors?
One for the state, Your Honor, and I've alerted Mr. Bradsher to this. I last night was informed by Agent Whitley of the SBI that Tyler Henderson, who testified late yesterday afternoon's now ex-wife, then wife, contacted him and said, or asked the question, do I need to be interviewed? There is no report or anything generated to that effect that I'm aware of about that phone call from last night. My response to the SBI at this time was very specific to that question, do I need to be interviewed? Our response was, not to our knowledge. If something were to change, we will let you know. I don't know what, if anything, she would have to share. She did not provide any information about what she was calling or what she was calling about. So I don't know if there's any exculpatory or inculpatory information contained. That was the extent, and I never spoke to her. My understanding is that Agent Whitley called her and gave her that information, and no new information was provided. I alerted Mr. Bradsher to that this morning so that he would be aware. I don't think there's any obligation for us to go and seek her out and conduct a new interview. Obviously, as I've said earlier, if Your Honor orders me to do so, we would comply, but as of right now, we do not have the intention of doing that.
All right, Mr. Bradsher.
I talked with the state about it this morning. The defense doesn't seek anything from that, Your Honor.
All right, very good. Anything that you need to bring to my attention, sir?
Just briefly, Your Honor, I just wanted to get some direction from the court. My charges, as you know, relate to 3 obtaining property by false pretense related charges for a time period between April 1st and October 24th, and then 3 obstruction related charges that have specific dates of events. I believe September 6th, my interaction with the SBI agent, as well as a date with Mr. Stoltz, I believe in August, and then with regards to Ms. Hallberg on January 11th, 2017, when the state elicited testimony from Mr. Henderson, which absolutely material and relevant. As part of the foundation to establish credibility for their witness, they went through years where he worked for me in private practice and then discussed his duties with me during the first term in office as district attorney. I felt like that gave me the right to, on cross-examination and confrontation clause rights, to go into specific instances of conduct that spanned back during that period of time. The court, at a certain point, gave me multiple objections on that point, and ultimately I asked to be heard, and I was not allowed to be heard at that time, and I'm not arguing with the court. The court has the right to determine what they consider as relevant evidence. My question, I guess, in motion going forward is there some mechanism that can be put in place for 2 things, that in the event that I get in that situation again where I feel like there's a good faith basis to elicit facts on cross-examination and the reason why, where I can be heard on that issue with a little bit more detail, and the mechanism the court would want to put in place for me to make some type of offer of proof after that. Again, I know this court has the discretion to narrowly limit the evidence to the offense dates and anything that's relevant to kind of explain that, like we have discussed the initial exchange of spouses between the 2 districts. I understand that that's fair game. I also know that most of the evidentiary rulings on materiality and relevancy will be within your discretion. I just would like the opportunity, if I get into that situation again, to be able to explain a little further to the court why I feel like I have the right to cross-examine that. And that's just a brief motion. Prospectively, I'm not saying anything about yesterday. I chose to go on. We completed that witness, and I'm ready to move forward.
Right. So typically, there are some instances where there's an objection or a issue that comes up where I send the jury out and we take that up on the record. I think we've done that on occasion. There are other instances where I make a ruling, I'm satisfied with the ruling that I have, I feel confident that I understand both the state's basis for the objection in the instance yesterday and your basis for wishing to be heard on it. And my practice in those instances, rather than interrupting or utilizing the time that we have with the jury, I find the more efficient way of conducting the trial is simply to allow that to be done during a break, give you the opportunity to be heard, make an offer of proof, whatever you need to do, and perhaps if you were to change my mind, if we were doing it at the next available break, the witness is likely still there, perhaps even still on the stand, and we can go back and cure any error that I have made. So that's generally my practice when I feel satisfied that I understand the scope of your concern and what you wish to be heard on. I certainly don't want to prevent you from making a record or offering proof or even trying to change my mind on a ruling, but I do it the way that I prefer to do it in many instances is just simply, let's take that up at the next break. That way the jury, we use the jury's time most efficiently.
Yes, Your Honor, and that's specifically what I was trying to get to. Before I tender the witness back, should I approach the bench and alert the court to that, ask all the questions that are not objectionable, and when I'm at the end, approach it, or should I just tender and wait till that witness is complete? I was just trying to, in terms of the timing, trying to get direction from the court.
Right. It really makes no difference. I don't have a problem with recalling a witness if I've changed a ruling and at the first break after I've made a ruling, I hear from you, you persuade me that my ruling was incorrect, I change that ruling, I have no problem calling the witness back and saying we have a few more questions for you and allowing that to happen. So again, it's merely a matter of judicial economy. Yes. That I do it that way so that we maximize the time that we have the jury in the box to present evidence and not have them going back and forth while we deal with legal or evidentiary arguments. Sometimes we have to do that, obviously, but other times it's, in my view, more efficient just to do it the way I described.
Thank you, Your Honor.
All right. Very good. There was one question that the juror sent out that I feel perhaps I can clarify a little bit. The juror asked, you made a statement during Mr. Bradsher's first cross-exam of Cindy, she says Cindy Bradsher, that it's up to the jury to recall prior testimony. Could you provide us with additional instruction or clarification relating to this statement? What I'm inclined to say to that is that from time to time, lawyers or a party will ask questions appropriately that say, you testified earlier X, Y, Z. And that's a perfectly appropriate question. But the jury, it is the jury's duty to recall exactly what the witness testified to. And to the extent that an attorney or a party is attempting to restate a portion of the evidence and the jury's recollection of that evidence is different, the jury is to be guided exclusively by their own recollection of the evidence. That would be what I'd intend to say to clarify that question, because I do think it's important that the jury understand that ultimately it's not what you, in your roles as examining attorneys or parties, that is not the evidence. The evidence is what comes from the witness box, and it's important to remind the jurors that it is their duty to recall the evidence and decide what the evidence is. Any concern about having that dialogue with the jury?
As long as it applies to both of us, no objection.
I'll certainly apply it equally. All right, very good. Let's bring jurors, please. Good morning, ladies and gentlemen, and welcome back. Let's see, before we started with the next witness, there was a question from a juror, just to clarify that a brief instruction that I gave to the jury in response to one of the questions that was asked yesterday. And the question basically says that I instructed the jury that it is up to the jury to recall prior testimony. In the context of this, and the question is, can you provide us with additional instruction on that? And the context was that the state or the defense, in asking a question of a witness, may start the question with something like, you testified earlier XYZ. And that's a perfectly appropriate way to start a question, to orient the witness to where the question is going. Well, your recollection of that, you testified earlier XYZ, might be different from what the attorney or the party recalls. And it's up to you to recall what the evidence is. So if an attorney or a party attempts to restate a portion of the evidence and your recollection of the evidence is different from that stated by either the state or the defense, it is your duty to be guided exclusively by your recollection of the evidence. So I hope that clarifies that question that I was asked. Now, with that being said, we're going to ask the state, is there further evidence for the state?
Yes, Your Honor. The state would call Gayle Peed.
Again, if you would please place your left hand on the Bible and raise your right hand. You solemnly swear that the testimony you give before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Mr. Latour?
Thank you, Your Honor. Ms. Peed, when you're comfortable, you may have heard yesterday, if you'll speak into the microphone so the jury can hear you, but introduce yourself to the jury, please.
Gayle Peed,
Ms. Peed, how are you employed?
employed with the Person and Caswell County District Attorney's Office
How long have you worked for the Person Caswell County District Attorney's Office?
since January of 2011.
And what did you do for a living before you worked in the Person or Caswell County DA's office?
I worked as a legal assistant with Bradsher and Perkins, and before that with Bradsher, Grissom, and Holloman.
And was that a law office?
It was,
Who was
yes.
the main law partner there that you dealt with?
Mr. Bradsher,
Right, the defendant?
yes.
All right. And in 2011, when you come into office, who do you come into the DA's office working for?
Mr. Bradsher,
And you worked there continuously ever since?
yes, sir.
We've heard testimony that there are two different offices within that prosecutorial district. Is that right?
That's correct.
Where is your main base?
My main base is in Person County, in the Person County office in Roxborough.
Do you travel between the two?
I do. I spend primarily most of my time in Person County, but I do try to be in the Caswell office several times a month.
All right. And what's your role in the district attorney's office in Person, Caswell County?
I'm the administrative assistant.
Can you tell us a little bit about what that is?
I do all the administrative work for the office, all of the paperwork for hiring new employees, for transferring employees, for separation of employees, support for the DA and the assistant DAs. I also do support for Superior Court, for the administrative and the trial weeks in Superior Court, generate calendars. There's lots of stuff I do.
A woman of many hats there.
Yes.
All right. Is that what you've done since you were hired there, or did you do other things?
Basically, that's what I've done the whole time.
Now, are you aware of eventually there comes a time, well, you know Wallace Bradsher's wife, Pam?
I do,
And
yes.
is that her in the courtroom?
It is, yes.
And how did you know Pam Bradsher?
Well, I've known Pam my whole life, pretty much. We grew up together, grew up in the same church.
All right. And did you two work together?
We did, yes,
Okay. And did the two of you work together in the district attorney's office?
we did.
And while working together in the district attorney's office, do you know what her role was?
She started as a victim witness legal assistant.
Okay, you say she started as that. At some point, did that change?
It did,
Do you know what it changed to?
to the DA investigator.
All right. And at some point, were you made aware that Pam Bradsher could no longer work in your office?
I was.
Do you remember when that happened?
Just based on what I know from everything, January of 2015. I can't tell you the exact date, but January 2015,
Early January or late January?
early January.
And in early January of 2015, how did you, if you remember, become aware that that was happening?
Mr. Bradsher told me that he had received a call from the administrative office of the courts.
All right. And at some point when you find all of this out, are you made aware of any decision to hire a new person in place of Cindy in your office? I'm sorry, in place of Pam in your office.
Yes,
What are you made aware of?
that Pam would transfer to the Rockingham District Attorney's Office and Cindy Blitzer would transfer to our office.
Now you call it a transfer. How did that, if you're aware, were you involved in that transfer at all?
I was involved in the paperwork, yes.
Okay. So the actual logistics of making the transfer happen, you were
Yes.
involved in.
Yes.
Can you tell us generally how that occurred?
I believe my contact with the administrative office of the courts would have sent an email to myself and Melinda Richardson, who is the AA in Rockingham, and sent us paperwork that Pam and Cindy would need to fill out to make that transfer.
Okay, now the paperwork that would be sent to make the transfer, is it just one form where everybody says we're switching places, or is it a step-by-step process?
It's definitely not as many forms as you fill out when you're a new employee. I think there were maybe 3 forms that you have to fill out to do that.
In order to make this change happen, did you have to terminate employment first?
So the form is called separation of employment, but on that form, there's a block that there's choices, and one of the choices is transfer to another district attorney's office. And so I guess, I don't know if you call it termination or separation or transfer, but there is a block on that form that you check to transfer to another district attorney's office or to another office.
Okay, may I approach, Your Honor?
Yes.
I'm going to show you what's already been introduced as State's Exhibit 5.
Okay.
This is has been testified that it's Cindy Blitzer's personnel file. Now, I understand are you familiar with a personnel file like this?
I'm familiar with mine. If that one came from AOC, I'm not familiar with everything that's in there.
Okay. What I'm going to ask you to do is, you've testified about this separation form. Will you look through this document and see if you locate a separation form as it would relate to Cindy Blitzer? And I know you did not testify that you did that, but for Cindy.
Okay. This is a separation of employment.
Okay. So there's a separation of employment for Cindy Blitzer.
Yes.
Now, the language in here that you testified to, there's a block that says transfer to another judicial branch office, and then where you can
That's
click
correct.
on it. But it's called a separation.
It is,
form.
yes,
And
it
so,
is.
In actuality, is what's happening, you have to separate from employment with one group, obviously, before you can be employed by a second group, correct?
That's correct, yes.
All right. And so once that's filled out, then you had to do another piece of paper?
There's a security form that you have to terminate your security access from one office and reinstate it for another office. And then I think they had to fill out another personal data sheet that just gave basic information about their position and salary, different things like that.
Okay. And once all that's done, it's sent to AOC?
Correct?
And would this have happened around January the 14th of 2015?
That sounds about right.
Okay. And you would have filled all that out for Pam Bradsher, not for Cindy Blitzer. The separation
The
form.
separation form, yes, I would have filled out for Pam, and Melinda Richardson would have done it for Cindy.
And then the second form you would have filled out for Cindy, and Melinda or someone would have filled out for Pam.
Correct.
Okay. Now, is one of your roles, well, let me ask you, when were you made aware that this transfer was going to happen? Was it before the decision was made or after the decision was made? If you remember.
I'm assuming it was after the decision was made.
Okay. And is one of your roles, and you may have testified to this earlier and I missed it, are you familiar with Beacon?
Yes.
How are you familiar with Beacon?
Well, I enter my own time in Beacon, and then I approve other employees in the office.
Okay. When you say you approve other employees in the office, what do you mean by that?
Support staff in the office enters their time into Beacon, and that's released to me, and then I go in and approve that.
Around 2015 or 2016, do you know how many support staff or approximately were in your office?
Including myself, probably 6 or 7. I'm
Okay.
not sure. I have to think about it.
And that would include you and Cindy Blitzer, or?
Yes.
Okay. And of those support staff, do you approve any of the support staff's Beacon time?
I don't approve my own, and I approved everyone, all the rest of the support staff, but I did not approve Cindy Blitzer's time.
All right. Now, we've heard testimony about these two offices. Do you approve all the support staff just in one office, or do you approve the support staff in both of the offices, except for you and Cindy?
In both offices.
All right. And why? Obviously, you don't approve your own time. Who approved your time?
In 2015,
Yes.
Luann Martin.
All right. Excuse me. And for a period of time, do you recall if you had to approve Cindy Blitzer's Beacon time?
I didn't go into Beacon and approve it, but a lot of times when you have a new employee, it takes a few weeks for Beacon to get set up. And so there ends up being some emails back and forth with our salary specialist at AOC. And I did. She sent me some times that she wanted to know if Cindy had worked those times. I sent those to Jay Stoltz. He sent an email back to me, and I sent that back to AOC.
Okay. What about, well, how long did, if at all, did Cindy actually work in either, I guess it would be Caswell County?
How long? I mean, she's,
Actually attend work in Caswell County? Was there a period of time where she was working in that district?
there was.
Was it a long, do you know how long it was?
I don't know exactly, no.
Long period of time, couple weeks, a couple days? If you don't know, that's fine
I don't
too.
know. I don't know for sure the length of time.
Okay. Now, at some point, are you made aware that Cindy Blitzer is no longer going to be working in your district physically?
I know that Pam Bradsher was working back in our office in Person County, and I understood it to be that Cindy was working in the Rockingham office and Pam was working back in our office.
Okay. When was this?
I don't know exactly, probably a few months after the transfer of positions, maybe March, April. I'm not really sure. I can't tell you an exact time.
Okay. For a period of, excuse me, for a period of time, was there a time when Pam Bradsher was working not on site in Person, Caswell County, but presumably in Rockingham County?
Yes.
Okay. Can you estimate how long that period of time was?
Again, probably a couple of months, but it could have been longer, it could have been shorter. I can't tell you for sure.
Okay. Now, during that same period of time, would there have been a time that Cindy Blitzer is not working physically in your office, but is in Rockingham as well? If you are aware.
I'm not sure.
All right.
I'm not sure.
So at some point, you do know, I think you testified, that after a couple of months, Pam Bradsher comes back to your office.
That's correct.
When if there had been a change of employment again, meaning she's hired back in your office officially, would you have been the one to fill out that paperwork?
At that time, yes.
Did you fill out any paperwork to bring Pam Bradsher back to your office?
No.
Okay. So at the time she's working physically in your office, and you don't know where Cindy is at this point, right?
Correct.
Is she still employed by the Rockingham County office?
As far as I know, yes.
All right. Were you able to interact with Pam during that period of time?
When she was working in the Person County office?
Working in the Person County office while employed by the Rockingham County office?
Yes.
Do you know if she was working on Rockingham County cases or if she was working on Caswell County cases?
She was working on Person and Caswell County cases.
Okay.
Well, Person County cases in the Person County office.
Okay. During that period of time, how was she getting into the DA's office or into the courthouse?
We have badges that we use to get into the courthouse. When she left employment in January of 15, she had turned her badge in, and I had turned that into security. And so she was using another badge that I had in my drawer.
Do you know whose badge that was?
At the time, I probably couldn't have told you, but I know now that it was Tracy Day's badge, who was a former employee of our office.
And did you hold on to that badge for a reason?
I just kept old badges in the drawer just in case somebody left theirs at home or, didn't have it, or we had a visiting intern or a visiting DA, just so they could use to get in and out of the offices in the courthouse.
All right. And that's is that common?
It is, yes.
Okay. Do you know how she got that badge?
I would have given it to her, or, it's common knowledge that that's where the extra badges are, so someone else could have given it to her. I may have given it to her. I can't remember exactly which
Okay.
happened.
Now, for the period of time that Cindy Blitzer is employed by your office, do you know around how many times you physically laid eyes on her? If any?
Probably 3 or 4 times.
Okay. Now, do you know Tyler Henderson?
I do.
And how do you know Tyler Henderson?
I work with him currently and have worked with him over the last 10 years probably.
Okay. And in working with Tyler Henderson, has your work with him been pretty consistent? Meaning, you said that span of time, was there a period of time in there where you weren't working with him?
No, pretty consistently we've worked together.
Now, at some point, did you have to fill out some separation of employment paperwork for Tyler Henderson?
I did.
And when you did that, what prompted you to fill out that separation of employment history or separation of employment form for Tyler Henderson?
Mr. Bradsher told me that he would be transferring into the position in Rockingham County.
Now, is this before or after or do you know if at some point Pam Bradsher quits working in the DA's office?
I do know she did. I know she went to a job at PCC.
Do you know why she went to that job?
I don't know exactly, no, but I know she took a job at PCC.
Okay. after she takes that job, is it before or after she takes that job that you fill out this transfer paperwork for Tyler Henderson?
I think it was after.
Right. And when you fill out that transfer paperwork for Tyler Henderson, does anything as far as your day-to-day dealings with Tyler Henderson change?
He still comes to the Person County office and works.
Okay. Regularly?
Yes.
Similar question to what I asked you about Pam Bradsher. Do you know if while he is employed by Rockingham County District Attorney's Office and present in your office, if he is working on either Person or Caswell County cases or Rockingham County cases?
I believe he's working on person and Caswell cases mainly, I believe person cases.
Okay. And we heard maybe some testimony about some other things that he may have done. Are you aware of some other jobs that he did there?
I don't understand what other jobs.
Okay. Was he working on anything other than just cases?
He was working on discovery and setting up the digital discovery system that we were trying to get in place.
Okay. But a digital discovery, or is that a digital discovery system for the Person Caswell County office?
Correct,
Okay.
yes.
During that period of time, are you approving his beacon time?
No.
When Tyler Henderson leaves, and we've kind of heard some testimony about allotments and certain spots, are you familiar with that?
Somewhat, yes.
Okay. When Tyler Henderson's job is switched to be employed by the Rockingham County District Attorney's Office, are you aware if your office is able to hire anyone else to fill that vacancy that's created?
We did hire someone else to fill that spot.
Okay. And when you hired someone to fill that slot, do you know who you hired?
I believe we hired Ashley Ferguson.
Okay. And Ashley Ferguson would have been hired to fill what kind of position? A victim witness legal assistant or an investigator?
Victim witness legal assistant.
And when Ashley Ferguson is, if it was Ashley Ferguson, when she's hired, is she doing person slash, and I'll refer to both of them, but is she doing Person / Caswell County cases for you guys?
She is, yes.
All right. And all of this happens, or does all of this happen before the separation of employment for Cindy Blitzer?
It does, yes.
Okay. At some point, are you made aware of a State Bureau of investigation into this employment situation of Cindy Blitzer working for your office in another office sort of deal?
Yes.
All right. How are you made aware of that situation?
I believe Mr. Bradsher told me that he had gotten a phone call.
Okay. Do you recall when that was?
I don't recall exactly. I believe it was in around August of 2016. I don't know exactly.
Okay. Do you recall receiving a phone call, or did you get a phone call on August the 15th of 2016 from Jay Stoltz?
I'm not sure of the date, but I did receive a phone call from Jay Stoltz, yes.
Okay. And when you received a phone call from Jay Stoltz in August, right? Do you recall if you received one that was kind of after hours after work hours from Jay Stoltz.
It was. I was at home.
Right. And when Jay Stoltz calls you after hours, you don't have to tell us what he said to you, but do you recall what the content of the conversation you guys had was generally about?
I do.
What was the conversation about?
Approving Cindy Blitzer's time in Beacon.
Okay, and what was your impression of what was going on in that phone call?
Your Honor, I don't object to the hearsay if he wants to listen to the question.
Right. It's sustained to the extent that that this question is listing what a third party said. That would be hearsay. But what you understood, what you did in response to that call, or you can answer generally what your impression of that call was, if you can do so without stating specifically what someone said in that call.
Your Honor, just to clarify, I said I do not object if he wishes to elicit the specific hearsay question. I wanted to make sure that was clear on the record.
I'm sorry.
If he wants to elicit what was specifically said, I do not object.
I'm sorry. So are you objecting or not objecting?
I'm making it clear if he would like to ask, instead of dancing around for a summary and description, if he would like to ask what was specifically said, I do
All right,
not
that's
object.
fine. The record says I'm going to object to hearsay if he wants to elicit the question. Maybe.
I didn't say it clear enough. I'm sorry. Do
Okay.
not object.
All right, very good. Mr. Latour, I'm sorry, if you could go ahead and restate your question.
Okay. Jay Stoltz calls you after work in August of 2016.
Yes.
And when Jay Stoltz calls you, do you remember what he said to you?
Yes.
What did he say to you generally?
He asked me if I was approving Cindy Blitzer's time in the Beacon system.
Okay. And when he asks you that, what was your response?
No.
Okay. Did you say anything else to him?
I told him that her time, when I go into Beacon and look at my staff, I can see whose time is waiting there to be approved. And I did not have any time in my staff tab to be approved for her.
Well, were you the one that time that was approving her beacon hours?
No.
Okay. Did you and Jay have any further conversation on the phone at that point?
I told him that he probably should go back and check his Beacon and see if her hours were in there for him to approve, because
Okay.
they were not in mine to approve.
All right. Did he say anything else to you?
Not really.
Okay. Was this why do you remember this phone call? Did it stand out to you in any way?
Well, it just stood out because I wasn't approving her time, and I didn't understand. I thought he was, and so I didn't understand what the confusion was, I guess. That's
Okay.
the reason it stood out.
And at the end of that phone call, did you talk to him about it ever again?
I don't believe we did. I don't think so.
Okay. That's the end of that phone conversation, and then for that night, you go back about your business.
Yes.
All right. At some point in October, do you talk to Cindy Blitzer?
I did.
And when you talked to Cindy Blitzer, why did you call her? Or did you call her?
I did call her, yes.
Why did you call her?
Mr. Bradsher asked me to call her.
Okay. And when you called her, what did you say to her?
I told her that based on Mr. Bradsher not being able to speak with her, that we were terminating her employment effective the day that I called, which I believe was October 24th.
Of what year?
2016.
Did you talk to her ever again after that?
No,
Do you know who Debbie Holbrook was or is?
I do.
Who do you know Debbie Holbrook to be?
She was an employee in the Person Caswell DA's office with me.
What was her job there?
She was a victim witness legal assistant in the primarily in the Caswell office.
And at some point, were you involved in the termination of her employment?
I was.
And what was your involvement in the termination of her employment?
Mr. Bradsher asked me to come to his office. He dictated a letter to me, a termination letter for her, and then he and Miss Holbrook came to my office, and I was there when he terminated her employment.
Okay, and did you then fill out the paperwork?
I did.
All right, thank you. I don't have any other questions, Your Honor.
Cross-examination?
Thank you, Your Honor. Good morning, Ms. Speed.
Morning.
I'll start with the last point he made. Do you recall in 2015, when the second term was starting, that there was a change in chiefs from each county?
Yes.
So for the jury to understand, beginning January of 2011, with it being a two-county district, isn't it true that Luann Martin started as the Caswell Chief ADA in charge of that county, and Jay Stoltz was the Person County Chief ADA in Person County? Is that right?
That's correct, yes.
And in terms of the kind of chain of command, I and Ms. McAdams, who was the senior ADA, did most of the Superior Court trial work. Is that correct?
Yes.
Okay. And in terms of those two chiefs, they pretty much ran each county, although you as the AA kind of kept everybody straight. Is that right?
Yes.
Okay. Now, when the second term started 2015, was there a switch of chiefs?
There was.
All right. And at that point, did Jay Stoltz become chief of Caswell County? Is that right?
That's correct, yes.
And then Luann Martin came and was chief of Person County. Is that right?
Yes.
Do you recall that in 2016, Mr. Stoltz was running for district court judge against a sitting district court judge?
Yes.
And isn't it true that as a part of taking him away from those duties of running Caswell County, that there was a switch made where I was going to serve as interim Caswell chief?
Yes.
Okay. And do you recall that you've said in response to the state you worked with me in private practice and in the DA's office? It is true that I'm a little OCD on getting everything straight. Is that right?
Yes.
Okay. You recall receiving a call from me which led you to come to Caswell with other staff to try and straighten up discovery issues?
I do.
Okay. And if you could, I can't ask you to say what I said. If you could describe to the jury what you recall about getting the call from Caswell from me and then going over and what was done in Caswell in response to that call in the spring of 2016.
There were quite a bit of files that were not, as I understood it, that were not completed as far as all the discovery being delivered to the attorneys, to the defense attorneys. There were quite a bit of closed files on top of some file cabinets that had not been filed away. So there was quite a bit of things that needed to be taken care of.
Do you remember what other staff came with you to work on those files that week?
I think Tyler Henderson came over to help work on those. I don't know that anybody else did. I think it was the two of us and the other staff in Caswell.
All right. And during the next few months that followed, were you personally aware of an ongoing effort to audit files for discovery in Caswell?
Yes.
Okay. And then eventually was Ms. Holbrook, who was the primary legal assistant in charge of discovery in Caswell, moved to Person County.
She was.
And once she was moved to Person County, isn't it true that her duties were to process discovery, learning the new digital system? Is that right?
Yes.
Okay. And you saw the workspace that she worked in, and I guess you would have approved her hours as well. Is that right?
I did, yes.
Okay. Now, I'll back up to the beginning. You indicated to the prosecutor about how the transition occurred and how Mr. Stoltz was in the system of approving Beacon. Madam Clerk, could I have the next number? May I approach?
Yes, sir.
Manual must be marked as Defendant's Exhibit number 19. You just take a moment to look at that. Do you recognize Defendant's Exhibit 19 as an email?
I do.
And do you recognize your name on the top portion of the chain of the email?
Yes.
And would it have been something received from me to you?
Yes.
All right. And then do you see the second part of the chain after I sent an email to you?
Yes.
All right. And is your email address there?
In the second half?
Yes.
No.
Okay. So do you recall receiving that email?
I mean, yeah, I guess. Yeah. Obviously, I got it, yes.
Okay. I can ask you what I said in it. I want to ask you this. Does it refresh your recollection that as of February 3rd, that it was your understanding Jay's primary responsibility was to do Cindy's Beacon?
Yes.
All right. And then did the next step, once that is given, you're included in the email, what is NCAOC access request? You can explain to the jury.
Access request is just basically the security form that we have to send in to the administrative office of the courts for people to be able to access everything, the computer, all the systems that we use, and the beacon system as well.
All right. And then at 6:39 at night, behind you what's been marked Defendant's Exhibit 20. Can you look at that email for a second? Is that also on February 3rd?
It is.
Okay. And at 6:39 at night, you send an email, is that correct?
I did.
And who did you send the email to?
Sent it to you and Jay Stoltz.
Okay, and what did you say in that email?
Do you want me to read it? Or
If there's no objection, yes,
I don't object.
I'm sorry, you
I
are.
do not object.
Yes, that's allowed.
this is what I was referring to in our meeting Monday. Jay, you will need to fill out the security form, parentheses 151, and get to me when you get the checklist that I sent earlier today. Gayle.
All right. And at that time, Jay was Castle Chief, is that right?
He was, yes.
Okay. And then I'll hand you what's been marked at Defendant's Exhibit 21. And can you tell the jury the date, time, and who that email is from and who it is to?
It was from me to Jay Stoltz on Thursday, February 5th, 2015 at 12:49 p.m.
All right, and what did you say in that email?
You want me to read it?
Please.
Okay. Please approve whatever Beacon I have outstanding with you. Also, did you talk with Cindy about entering Beacon?
Okay.
And then there's something about S2 motions something
All right.
about a person.
And there have been previous testimony from someone from AOC about supervisors not necessarily approving Beacon. exactly on time
Right.
as not being out of the norm. So was this an indication to you to tell him to approve Beacon?
To approve my beacon,
Okay.
yes.
All right. And I'll hand you what's been marked as Defendant's Exhibit number 22. All right, is that an email?
It is.
And what is the date of that email?
Thursday, February 5th, 2015 at 1:22 p.m.
All right. And who is that email from?
Jay Stoltz,
All right, to you.
yes.
And what is it regarding?
Beacon,
All right. And does it involve Cindy Blitzer speaking or somebody else's?
I believe in a response to my email, it's my beacon and Cindy Blitzer's beacon.
All right. The prosecutor had asked you about your role in Beacon with Ms. Blitzer during the transition. Do you have some involvement just in terms of transitioning everything approved to Mr. Stoltz?
Yes.
Okay. And following up with that, I'll hand you Defendant's 23.
Okay.
What is the date and time of that email?
Thursday, March 5th, 2015 at 11:15 a.m.
All right. And who is that an email from?
From me to Jay Stoltz.
All right, if you could read for the jury what this was communicated to Mr. Stoltz in March of 2015.
We're having an issue with the dates of January 31st, 15th through January 23rd, 15th for Cindy's Beacon. I need you to respond to the entries below to certify they are correct. AOC has everything else straight through 2/27/15 except the dates below. And I've listed all of those dates with 8 hours worked, with the exception of January 19th with 8 hours of holiday.
All right, should AOC occasionally have issues like that, as the AA, they would normally reach out to you?
They
Is that
would,
right?
yes.
Do you recall when Ms. Blitzer's employment was terminated and we got the paperwork from the state to finalize everything? Do you remember that?
Yes. Mhm.
Do you remember coming to me about a request from someone from AOC, perhaps Shannon Mears, wanting our office to approve?
I'm going to allow well, I don't know what, I mean, I'm not going to permit hearsay. Your statement, you'll be
Yes, Your
given the
Honor.
opportunity to testify later under oath if you choose to. In terms of what she received, or whether she recalls a specific communication from the AOC, I'm going to allow that.
All right. Thank you, Your Honor. I'll rephrase the question. After notifying AOC that Cindy Blitzer's employment was terminated, did you receive any requests from AOC for approval of Ms. Blitzer's hours?
Yes.
All right. You recall whether it was by form or email or what the paper document was that you received that communication?
It was an email.
All right. And do you recall who it was from?
I believe it was from Shannon Mears. I believe she at the time was our assigned person.
Okay. And the reason why you believe it's Shannon Mears, she's typically the person that you would interface with on issues like this of personnel.
Yes.
All right. And did the District 9A office give a response to Ms. Mears on that request?
I responded back to her by email, yes.
All right. And was that after consultation with me?
Yes.
Okay. If you could tell the jury what you communicated to AOC about that request.
I believe I told them that I was going to forward those hours to Cindy Blitzer for her to verify that she had worked those hours.
All right. And then after a reasonable amount of time, was there any response from Ms. Blitzer?
No.
Okay. Do you recall on a form tendered by AOC, the District 9A's position about approving her hours and her lack of response?
Objection.
Sustained.
Oh. Ms. Pete, are you aware of a document that after, well, let me ask it this way. You've already established Ms. Blitzer never responded, is that right?
That's correct.
All right. Do you recall the District 9A office transmitting any other information to Ms. Mears about that issue?
I sent another email in response to an email that I received.
Okay. Who did you receive the email from, as you remember?
Shannon Mears.
All right. And after you received that, what did you reply that you recall?
That I had not received, we had not received any response from Cindy Blitzer, and she was under investigation, and so we couldn't.
Objection to, if we may approach.
Yes. So that previously instructed you on. All right, so outside the presence of the jury, there's a objection to this statement that's being testified to by this witness on the basis of hearsay. I'm going to allow Mr. Latour to ask some voir dire of this witness to determine the source of that statement, to determine whether it is hearsay or whether it is a statement of this declarant.
Thank you, Your Honor. Ms. Pede, this email that we're talking about after Cindy's termination that you apparently sent at the behest of the defendant to AOC, correct?
To a response from an email that I received from AOC, yes.
Right. Okay. What did the email say that you responded? Your email in response, what did it say?
I don't remember verbatim, but it was that Ms. Blitzer had not responded to the email I sent to her, and she was under investigation, so we could not certify that she worked those hours.
Now, this information that she's under investigation and you cannot certify those hours, where did that information come from?
After I talked with Mr. Bradsher, I showed him the email that she sent. Initially, the first time it was sent, he told me to email Ms. Blitzer and see if we could get her to certify those hours. Sometime later, they sent the email back again asking for a response, and I told them, I took that to him and said, Cindy Blitzer never responded, and he told me to tell them we couldn't certify the time because she was under investigation. So I answered the email in that way.
With the information that you received from the defendant?
Yes.
This is not something that you created and went and typed to them on your own. You may have put the words in, but the
Right.
words you put in were they the information that was relayed to you by the defendant? And
After I spoke with Mr. Bradsher, that was what I went back and typed.
it was not your decision to send this email of your own volition and your decision as to what you were going to put in the email. It was based upon the direction of the defendant.
Correct.
Okay, thank you.
Mr. Bradsher.
Yes. Sorry, I had just a couple of questions.
Okay.
You knew, at least as of September 6th, that there was an SBI investigation about this issue because you were interviewed by the SBI.
Correct.
This would have occurred sometime late October or early November, is that right?
It was in November, I believe.
Okay. So initially, step one, when you got these requests from Shannon Mears about the hours, you didn't know what to do, so you came to me, is that correct?
Correct.
All right. And the decision was made to send her a request to see if she would verify the hours, is that right?
Yes,
And then you did not get any response, is that right?
I did not.
And then as you worked with Shannon Mears for, I guess, 8 years now, almost 8 years, she follows up to you with another email, is that correct?
That's correct.
And do you remember, since we're in voir dire, what the request was? I mean,
I don't remember exactly. There were maybe a list of a couple of months of hours, maybe the last 2 months of hours that she had worked that hadn't been approved.
Okay. And in terms of coming to me and the guidance, I did say our office was not going to approve the hours because there was a pending investigation to that issue. Is that right?
Yes,
And then you went back and formulated an email response to Ms. Mears and sent it.
I did.
And you sent it in the normal course of business, is that right?
I did.
From the DA's office to Shannon Mears at AOC.
Yes.
All right. Thank you for that. And then I'd just like to argue, Your Honor.
All right, go ahead.
Your Honor, first of all, I think it could fall within a business record exception. Second of all, the state, an issue of fundamental fairness, has asked Ms. P other statements that I have made. In an attempt to clarify and cross-examine what the state has raised, I believe, even if deemed hearsay, this would be admissible. I also contend to the court in Ms. Tant, I specifically addressed this in cross-examination, and her response, not in response to any question, was if such document exists. So that has been put out in front of the jury through state's witness and cross-examination of Ms. Tant about first the effect of Beacon, the effect of the approval of Beacon, and then specifically about the non-response. Ms. Blitzer has testified. She indicated she did not respond to that email. And I contend, first of all, that it's not hearsay. Yes, this is a unique case because I am being charged for conduct in the official capacity as district attorney. And it is alleged that this has been an obtained property by false pretenses. And as a part of a regular business communication between the AA of District 9A and AOC, the administrative assistant transfers this information. I contend that it is admissible, Your Honor. And again, if you take it a step further, if this had been tried to be elicited some other way, for example, Shannon Mears, then the state could object it's Gayle Pede's email, so it's hearsay. It's her email to Shannon Mears. They've already objected to parts of the chain where other people are in the email. So this is not just Wallae Bradsher, an individual defendant, telling somebody else to tell somebody else something. This is the office of the district attorney transmitting to AOC a position on their inquiry on these hours. And it's clearly relevant. I know the court is balancing the hearsay issue, but I contend it would be fundamentally unfair for all those different reasons, at least for impeachment purposes of multiple witnesses, as well as allowable by cross-examination of this witness. It is not a self-serving statement. It is something I did in the course of business that was transmitted by the AA in response to an inquiry from AOC.
Yes.
A few responses. One, it's not a business record exception because this isn't a business record. There's no record being introduced at this point. So that argument fails on its face, I would contend to the court. Secondly, it doesn't matter if this is something I would contend that is done during the regular course of business or acting as the office. This is his statement that's being transmitted at his behest. He's the defendant. And it's not something that I have elicited. It is intended to mitigate his conduct. Therefore, it is the epitome of a self-serving hearsay statement. Furthermore, it's hearsay in response to hearsay, because the first email technically is not even admissible, and I would, in my motion, move to strike any response to this and the email that was sent by Shannon Mears as hearsay at this point, or the discussion of this email, or any content of it, not that she received an email from Shannon Mears. As to the discussion that it's clearly relevant, I contend the opposite. This is an email after the charged event. the date of offense for this ends on October the 24th of 2016. This is an email post that, I believe, based on the testimony, and therefore is not relevant. So it fails on all fronts as being admissible, and I would ask that you sustain the objection, rule that it not be admissible, and strike any answers that have already been given and instruct the jury to disregard them.
May I be here briefly?
Yes, sir.
It does matter because Ms. Tant, the state's witness, said that the approval of those hours go back and grant leave time. One of the charges that I face is the factual dispute on why hours were approved before. The district attorney's duty, and I'm talking not just me, everybody, is to seek justice. How can a defendant being charged in his official capacity, even there's an allegation of aggravating factors of official capacity, the official actions of the district attorney's office at my direction are at issue before this jury. For the defendant, who was the district attorney acting in his official capacity, for that evidence to be withheld from the defendant when this is the state's witness on cross-examination is fundamentally unfair. And I would ask the court to take a step back and look at the big picture. We can interpret the rules to narrowly construe a defendant's right to a fair trial by saying, we're going to say that that's inadmissible. Or we can more liberally construe the defendant's right to put in evidence on cross-examination with a witness presented by the state to make sure the truth of what happened, and this isn't subjective, this is a document that actually happened in response to an AOC request. They put on AOC, they put on all this personnel record, they brought in Beacon, they brought in the approval of hours, etc. And here, we're going to tell a jury who's already heard that Ms. Tant said, if it even exists, that the previous exhibit's going to be stricken and any mention about this is stricken. The reality of fairness to a defendant is, what message does that send that to that jury? Then they think, oh, well, maybe it really doesn't exist, when we all know it does. And it was in a regular communication, just like everything else.
All right. And I understand the balancing between the rules of evidence. Fortunately, the legislature and 200 years of precedent have established a balancing of fairness of trials and admissibility of evidence, and so I'm going to rely on black letter law for that. I do think that this is hearsay. It's your statement transmitted through your administrative assistant to the AOC. It's hearsay, so it's inadmissible. I'm not going to strike the prior testimony or I'm going to strike the answer that was given before the objection was lodged to the question we're discussing right now, but I'm not going to go beyond that. Certainly, and of course the problem, Mr. Bradsher, is that your statements, whether they're self-serving as Mr. Latour contends or whether, as you contend, they're simply statements made in your official capacity, they're subject to cross-examination like any other statement. And so they are hearsay. If you wish for that statement to be entered into evidence, then you will have the opportunity to testify, subject yourself to cross-examination, and the truth of that statement can be tested. But as it comes in right now, it's an out-of-court statement. The declarant is not subject to cross-examination at this moment. It's being offered for the truth of what was said. It's not subject to the business record exception, and so it's inadmissible. And so ruled. The objection is sustained.
Your Honor, may I at least ask that she sent a response to Shannon Mears?
Certainly. The fact that a response was sent and that furthermore that at the end of the day there was no verification of those hours. The office did not verify those hours. Those are the facts.
And I say that, I'm not arguing with the court's ruling, I just want to make sure it's on the record, Your Honor. The offense date is April 1st through the termination date, and AOC paid that money despite nobody approving that.
Right. I'm not ruling on relevancy. I'm ruling
Okay.
on hearsay.
All right.
All right. So if you could bring the jurors back in, please. Welcome back, ladies and gentlemen. Again, thank you for your patience. Don't concern yourself about what occurs in the courtroom during your absence. I'm going to sustain the objection and ask the jury to disregard the last response of this witness. Further questions, Mr. Bradsher?
Yes, consistent with the court's ruling, Ms. Peete. Once you received a request from Shannon Mears, again, asking for the approval of Cindy's time, did you consult me?
I did.
And as you had done for the previous 6 years, did you send an official response from our office?
Yes,
Okay. And you put the response in the email and you transmitted that to AOC, is that correct?
I did.
Okay. And without saying the contents of the email, after that, did you receive any other communication from AOC with regards to that issue?
No,
Okay. And at that point, involvement in terms of Cindy Blitzer's employment was over, is that right?
that's correct.
Okay. Now, I wanted to clear up one thing from the beginning of your testimony with Mr. Latour. You indicated in 2015 Luann Martin was approving your time. Is that right?
She was.
Okay. And at that point, she was the Person County Chief. Is that right?
She was, yes.
Okay.
There may have been a little bit of time transitioning from Jay Stoltz approving my time to Luann approving my time, but for the majority of 2015, she approved my time because she was the chief in Person County.
All right. And do you recall who approved your time the first 4 years?
Jay Stoltz,
All right. And at that time, he was the Person County Chief.
yes.
All right. Now, you were also asked about some of Tyler's duties before he became an employee of Rockingham and after. Do you recall that?
Yes,
Do you recall Mr. Henderson? Well, first of all, you were here yesterday for Mr. Henderson's testimony. Is that right?
I was, yes.
Okay. And did you see him? Well, let me ask you this first. Were you aware that he went to Rockingham to get the Shockley file?
Yes, I think I remember some talk about that when that happened, yes.
All right. And from your personal knowledge, you know that he worked on the Shockley file.
Yes,
And do you know that he went to Rockingham for the Shockley plea?
I'm assuming he did. I don't remember exactly when that happened.
All right. You were asked several questions about allocation of resources, where everybody was and whose work they did and things like that. You remember those questions?
Yes,
Yeah, it is fair to say that in terms of all of the allocation of resources during the 6 years and a half years I was district attorney, those final decisions were mine. Is that correct?
yes,
Okay. Isn't it true that we set up a chain of command and had daily assignments in terms of schedule, courts, and locations? Is that right?
yes,
All right.
yes,
So as AA, the administrative assistant in our chain of command, isn't it fair to say that Ms. McAdams as senior ADA and you as AA probably had the most involvement with me on a day-to-day in terms of administration?
yes.
Do you recall at the end of the first term a meeting where Ms. McAdams and you and I put on the big screen to evaluate salary reallocation?
I do.
Okay. And that was a process where we had input and evaluated resources and made some decisions. Is that right?
Yes,
And after that meeting and discussion, you would be the one that would do the administrative paperwork to help effectuate that interfacing with AOC. Is that right?
yes, I would.
All right. Now back to resources. Mr. Latour has asked you about people in Person County doing Person County work or Rockingham work, etc. Do you recall, because you said we were in private practice together, that when the transition was made to district attorney's office, that there were a number of conflict cases that existed from former clients of mine that I could not prosecute?
Yes, there were.
All right. Several hundred, wasn't there?
There were a lot. I don't know the number, but there were a lot.
And over the course of the next 4 to 6 years, even to the time period Mr. Latour has asked, had there been other prosecutors and legal assistants and investigators that have come to Person and Caswell to assist in resolving those cases?
Objection.
Overruled.
Yes,
And from your personal knowledge, who's Melissa Pelfrey?
she's the former district attorney from Halifax County.
And from your personal knowledge, did I and our office take a number of conflict cases in Halifax County?
We did.
And over the course of the 4 to 6 years of having those, did myself and other ADAs and an investigator and staff go to Halifax and do Halifax County cases?
Yes,
Could you even guess at how many trips to Halifax there were made?
a lot. I can't say a number, but there were a lot of trips to Halifax.
And with regards to that, would Miss Melissa Pelfrey also come and bring staff and do Person and Caswell criminal cases?
She would, yes.
And without belaboring the point, what you've described in terms of the interplay of resources between Halifax and Person and Caswell, isn't it true that that was also the case with Granville County and that district with Mike Waters, that we did conflict cases?
I believe we did, yes.
Isn't it true that we did that with Roger Eccles, the elected DA in Durham County?
Yes,
And isn't it true that we did that with Pat Nadowski, the elected DA in Alamance County?
yes,
And we also did that with Craig Blitzer in Rockingham County as well. Isn't that right?
yes,
And all those times, we spent ADA, DA, investigator, and VWLA resources from our district doing cases for people in other districts. Isn't that right?
Objection.
I'm going to allow it, but I'm going to ask you to move along.
That was my last one.
Relevancy is
Yes, sir.
limited.
yes.
All right. Thank you. You gave a statement to the SBI on September 6th. Is that right?
I did.
Okay. May I approach the witness, Your Honor?
Yes.
I'm handing you what's been marked as Appendix 24, the statement, just to refer to.
Okay.
Do you recall September 6th, 2016, where Agent Whitley with the SBI came and met with me in my office?
Yeah, yes, it was the same day that he met with me.
All right. So my office at the time was second floor, is that correct?
It was.
All right. And then after I met with Agent Whitley, did he come down and meet, did you see him meet with Luann Martin?
I did.
And then did he meet with you?
Yes,
Okay. And then across the hallway, on the way to Ms. McAdams' office, was Tyler Henderson's office located right there?
it was.
And then he bypassed Mr. Henderson and he went and talked with Ms. McAdams, is that right?
He did.
So you've taken those 4 statements that day. Did you observe him take any other statements?
No, I didn't know if he talked. I don't think he talked to anybody else that day.
All right. Can I try to ask this in an admissible way? Isn't it true, I did not bring in a lawyer to talk to?
Sustain.
Without saying what was said, did I communicate with my staff about cooperation with the SBI?
Objection.
Overruled.
Yes, you did.
Okay, I got to stop there. Let's go to the report. And then, when you met with Mr. Whitley, Agent Whitley, he asked you questions and you gave him answers. Is that right?
I did.
Okay. And in terms of this typed up report, had you ever seen this before?
No, this is the first time I've seen it.
Okay. He asked you some background information, isn't that true?
He did.
All right. And isn't it true you described to him that you did the administrative supervision of the staff? Is that right?
Yes.
Okay. And then if you can look over at the next page, isn't it true that y'all discuss Beacon and vacation time and things like that?
We did.
All right. And do you see in the second paragraph, isn't it true you said, Pete stated that when she said that she would approve their time, she meant that the employee would enter their time in the Beacon system and Pete would look at it, and if everything matched what Pete had, then Pete would approve the time the employee had entered. Is that correct?
Yes.
So as the AA with the two-county district, you did not personally observe everyone that worked for the approval of their time, did you?
No.
This was, you trusted the entry of an employee as to their time, is that right?
I did.
And in terms of checking to see if anything matched, isn't it true that what you would look for is, was there vacation that time or a sick time, and did the employee make a mistake putting in time where they were actually on vacation, something like that?
Yes.
All right. So it wasn't that you were going over and monitoring some security system to make sure that they were there every hour they said they were there?
No.
Okay. And you, as the AA, interface with AOC and did the little module on supervision with AOC, right?
I did. Yes.
And you interface with other judicial districts and talked with other AAs, is that correct?
Yes.
And all this time that you did approval of Beacon, did you believe you were doing it according to the way it was supposed to be done?
I did.
Okay. So then in the third paragraph, do you see where you indicate that ADAs were not hourly employees and that so that they were not entered? You see that?
Yes.
And you told them that Luann Martin was approving your time. You also told the agent that Jay Stoltz was approving Cindy Blitzer's time. Is that right?
Yes.
Okay. This system that has the Beacon and the supervision, when you say you go into it and see what's released, can you tell the jury what you see when you go into this computer system?
It's a screen. It'll initially have all the people that have released time to me, and how many hours they've worked on a particular week. And then when I click on it, their number of hours that week, it will show each day how many hours they worked and if they were time worked or vacation or sick, holiday, anything like that.
And was there a function that would tell you if a supervisor was late in approving?
Sometimes AOC would send emails saying that you had time in your approval box that had not been approved.
Okay. And that would go to whoever was in the system was the supervisor?
That's correct, yes.
Okay. And so, do you know or have you ever gone in the system to change who was going to be the supervisor for the purposes of approving Beacon in the system?
I can't change that. I have to talk to someone at AOC to make that change.
All right. So, for example, you've told the jury first term Jay Stoltz was approving your time.
Right,
Second term, Luann Martin was.
yes.
So do you know who would have to go into the system to switch that over with Beacon for the approval?
Someone at AOC, I would send an email saying this person needs to be changed to a different person for approval, and then I'm not sure who did that, but somebody would make that change.
Okay. And then whoever is the new designated supervisor, would they get a notice or would they have to go into Beacon and see if something had been released to them?
I don't think they get a notice. I just think they know that they're going to approve that person's time, and they go into Beacon and do that.
Okay. All right. Then they talked to you about Miss Blitzer and where she was. Do you recall telling AOC, Pete stated that Cindy Blitzer had been given projects such as conflict cases in the past by Wallae Bradsher? Do you see that? I'm sorry.
Which paragraph is that in?
Fifth paragraph, next to the last line.
Yes. Well, yes.
Okay. And then on the last page, isn't it true you told the SBI that you had not worked with Cindy Blitzer because Cindy Blitzer had worked in the Castle office? You see that?
Mm-hmm.
All right. You do indicate that you did work with Cindy Blitzer to complete new employee paperwork. Is that correct?
Yes.
All right. And isn't it true further down, you say Pete recalled that she did certify Blitzer in the Beacon system initially for the first few weeks of Cindy Blitzer's employment with the Person Castle office, and was that in response to the email that we've talked to the jury about already?
Yes.
Okay. And then is it true you told the SBI, Pete said that after the first few weeks, then Stoltz began approving Cindy Blitzer's time in Beacon, is that right?
Yes.
Okay. Now, next to the last paragraph. SBI agent was asking you about Tyler Henderson, is that right?
Yes.
Okay. In the first sentence, do you recall telling the SBI, Pete stated that as part of a sharing program, the District Attorney's Office, a person in Castle, was sharing with the Rockingham County District Attorney's Office, is that right?
Mm-hmm. Yes.
And you told them as of September 6, 2016, that Tyler Henderson worked for this office and Cindy Blitzer worked in the Rockingham County District's office. Is that correct?
Yes.
All right. And you indicated that you believe that Cindy Blitzer worked from home generally. Is that right?
Part of the time, yes.
Okay. And did you say Pete stated that Henderson was employed by the Rockingham County District Attorney's Office and she was not sure how this actual job position was classified? Is that right?
Yes.
And in the tree, you also said that Henderson helped the Person County office with updating their discovery procedures. Is that right?
Yes.
And you also indicated that Pete stated that Henderson was present in the office every day and he did a good job.
Yes.
Final question. Where your office is located and you were interviewed by Agent Whitley, he came to your office from Luann's office, is that right?
I believe he interviewed me first and then
Okay.
went to Miss Martin's office after me. I
Okay.
believe that's the way it happened. I'm
All
not
right.
positive, but I think so.
And then Miss Martin's office, he went and talked with Miss McAdams, is that right?
Yes.
Isn't it true, based on your own personal knowledge, that Tyler Henderson was in his office with the door open next to Miss McAdams' office?
I believe he was there, yes.
And you told Agent Whitley about Tyler Henderson and his role in this, what you've just told the jury, is that right?
Yes.
And although Tyler Henderson was there in the office, isn't it true that Agent Whitley just interviewed the three of you after interviewing me And he did not interview Tyler Henderson.
I don't believe he interviewed Tyler that day, no.
Thank you, ma'am. Nothing further.
Mr. Latour?
Very briefly, Ms. Peed, one of your main job, or I don't know if it's one of your main jobs, is one of your main jobs this beacon thing?
It is.
Okay. You do a diligent job at that?
I try to. Every week, try to.
Okay. Every week you're in
I do.
reviewing, trying to approve?
Yes.
Okay. Why do you do that?
Because I don't want a backlog of things that I need to go in and do. It's easier if I do it every week, and it does help with their accrual of people's time, vacation and sick time, so they have an accurate reading of what they have.
Okay. And so you take that job seriously?
I do.
I want to ask you very briefly about a couple of things that were elicited on cross-examination.
Okay.
And in your statement to the SBI on page 2, you were asked about Cindy Blitzer being given special projects.
Which paragraph is that?
It would be the third from the bottom. Given projects and conflict cases in the past. You see what I'm talking about?
I don't. I'm sorry.
May I approach?
Yes, sir.
Yes.
This is the first time I've ever seen this.
I
So.
understand. I'm not trying to quiz you on it. I'm sorry. I guess I am. Page 2.
That would help
Sorry,
if
I
I
didn't
turned
know
it
yours
over,
were-
wouldn't it?
I didn't know yours were front and back. So that, well, yes, the third from the bottom, this paragraph.
Yes.
Okay. Now, what I want to ask you about is, are those projects and conflict cases something that you have personal knowledge that she was given, or are those things that somebody may have told you about?
I didn't have personal knowledge about what they were specifically, no.
Okay. So you told that to the SBI, but you didn't know, you don't know, or let me rephrase that, I'm sorry. Do you know anything about special projects or cases, conflict cases, personally, that were given to Cindy Blitzer?
No.
Okay. Now, looking at page 3 of that statement, all right, you talk on that page a little bit and you were questioned about an employee sharing program.
Yes.
Okay. Do you know personally about a sharing program?
I know what I was told about it, that they were working in that.
Well, don't tell me what you were told.
Okay.
What I'm asking you is, do you, Gayle Peed, as you sit here today, have any independent recollection of a program approved by AOC or anyone else, well, approved by AOC of a employee share program?
I object to the conclusion that this has to be an approved AOC program.
Overruled.
Do you know of any approved AOC employee sharing program?
No.
Okay. This sharing program that you mentioned, do you have any personal knowledge of this program? Or do you just know that people were in two different places?
Yes. That I know that they were in two different places, yes.
Okay. And you were asked about a statement that you said, you believed Cindy Blitzer generally worked from home, right?
Yes.
Do you have any personal knowledge about Cindy Blitzer working from home?
Not personal knowledge, just what I was told.
Okay. Now, those cases, you talked a lot about conflict cases over this period of time that you worked in the office and the 5 or 6 different counties that y'all took cases from and got cases from, right?
Yes.
Okay. Those cases that you saw Tyler Henderson and Pam Bradsher working on that you testified about in 2016, is that right?
Well, Pam would have been 2015.
Okay. The cases that you saw Pam working on while she was employed by Rockingham County and working in your office,
Yes.
were those conflict cases or were those Person County cases?
I believe they were Person County cases. I didn't work with her on a daily basis of those, but I believe them to be Person County cases.
Okay. Same question, but for Tyler Henderson. When Tyler Henderson is employed by and being paid by Rockingham County, but working in your office, are those conflict cases to your knowledge, or are those Person and Rockingham County case, or Person and Caswell County cases?
I know he primarily worked on Person and Caswell cases, but I do know that he worked on that Shockley case.
The Shockley case.
Right.
Other than the Shockley case, any other conflict cases that he was working on that you have personal knowledge of today?
Not to my knowledge.
Okay. Thank you. No further questions.
Mr. Bradsher?
Yes, briefly. During the same time frame generally that Mr. Latour's asked about, did the District 9A office begin transitioning to a digital discovery system from paper?
Yes.
And through that process of generating discovery, did you see a transformation from receiving discovery in paper, processing paper, and delivering defendant's discovery paper to a digital process?
Yes.
And ultimately, after a year or so, did it even go to paperless files? Is that right?
Yes.
Okay. And so during this transition period that Mr. Latour's asked you about, where there is Pam Bradsher and Tyler Henderson, that is the same time frame that things begin transitioning to adopt this digital system. Is that right?
Yes.
Thank you, ma'am. Nothing further.
Thank you. You may step down. Ladies and gentlemen, we're going to take a 15-minute recess. We'll resume at 25 minutes till 12. Please recall all the instructions I've given you. Leave your notepads in the chairs and gather in the deliberation room at 25 minutes till 12. Everyone else, please remain seated while outside the presence of the jury, are there any matters that we need to take up?
Just briefly, a scheduling matter, Your Honor. My next witness, and I'll tell the defendant that my next witness, I believe, will be Agent Whitley with the SBI. Knowing how things have kind of been going, I don't know how long of a witness that will be. I will tell you that I, as we sit here now, do not have another witness after that. I could get them, but if we anticipate that it's going to be a lengthy witness into the afternoon, I don't want to have somebody come down here and just sit to sit.
I don't think he has anything to worry about, Your Honor.
Right, that would be my guess as well.
That's what I thought. I just wanted to put everybody on notice.
All right, fine. So I think that's a reasonable thing to do is just, we'll have Agent Whitley here for the rest of the morning, as long in the afternoon as we go, and then if by chance we do conclude Agent Whitley prior to 5 o'clock, then we'll recess at that time for the weekend. All right? Maybe that's some incentive. In any event, anything else, Mr. Bradsher, anything you need to bring up to my attention at this
No, Your
time? All right, very good. We'll be in recess until 25 till.